Good evening. We are here today with Andrea Carlevaris, our partner in BonelliErede, who for the second time has taken his lesson inside this specializing master contract claim in delay management in construction works. The title of his presentation is Arbitration Context, Jurisdictional, Procedural and Substantive Issues in Construction Disputes. And we are here for him to summarize the contents of his lesson.
Thanks very much. It's a pleasure to come back to the Polytechnical for this master. My lesson basically deals with the last steps in the life of a claim in the context of a construction project, which is after the preparation of the claims and the submission of the claims to certain contractual mechanisms, including engineers and dispute boards. The last step is when it wasn't possible to settle the dispute otherwise, is arbitration. Arbitration is obviously not the only solution for a claim. The claim may be submitted to state courts, but in modern construction practice, it has become normal, especially for large international projects, to submit disputes to arbitration. This is also what is provided for by the most commonly internationally used forms of contract, like F.lli or other forms of contract, which provides as a default arbitration. And so we observed all the phases of the arbitration, from the jurisdiction of the tribunal to procedural issues to merits issues that arises typically in the context of construction disputes on the merits, to the post-award phase, how to enforce or to challenge an arbitral award. And we observed all of these steps from the point of view of a construction project. And so what is typical and characteristic of an arbitration concerning construction claims.
Okay, thank you. So basically you're saying that arbitration should be avoided if possible, but
of course it
so
should
it's
be
not
avoided.
the opt for a solution of a problem, but sometimes you cannot do without it.
It is inevitable.
It is inevitable.
Absolutely.
Okay.
And experience shows that construction is by far the first industry in which disputes are brought to arbitration. For example, the ICC, the International Chamber of Commerce, which is probably the best known institution administering arbitration proceedings, has as the first category of disputes administered and registered every year. The number one is construction disputes. So it is extremely common. It is almost inevitable in complex projects to have problems and to have claims. Hopefully some of these claims, or most of these claims, are resolved during the normal day-to-day life of the project. But this is extremely unlikely that all disputes can be resolved before being brought to arbitration.
Okay, thank you. And the role, our students basically are engineers and architects, mostly. And the role of a technical figure, of a technical professional figure in arbitration of these kinds, which is exactly how they are involved in it.
Construction arbitration has, I would say, inevitably a very important technical component. So technical persons are regularly involved in the preparation of the claims, and sometimes even in the conduct of the arbitration. It is normal for the parties to rely on their technical staff to prepare the claims and to present them in arbitration. It is normal for the parties to resort to experts on specific technical aspects of their claims, and it is also not uncommon for arbitrators to come from the industry.
Mm-hmm.
Sometimes, generally, I would say not all the arbitrators in a tribunal will be technical persons. There is obviously, inevitably, also a legal component, but there are engineers or architects that are also extremely experienced in sitting as arbitrator and so directly resolving the disputes themselves.
And your experience, your firm is a law firm. In your experience, technical people like architects or engineers basically are employed by general contractors or sometimes also by firms in the law field?
Well, let's say law firms generally don't have architects or engineers among their members or partners, but we regularly resort to the assistance of external professionals in these fields. And I would say
they should be well versed in this kind of topics.
Yes, absolutely, and I think what is interesting is there is also an osmosis in construction arbitration between legal and technical professionals, which means I know many technical professionals who know certain basic legal principles of how to conduct a procedure, respective process, and also apply the law. And at the same time, I also know many lawyers who have developed particular skills in if not themselves to resolve technical issues, at least to know where to find the right answers to the technical questions that arise in the life of a construction arbitration.
Okay, thank you very much, Andrea. Always useful, and I really hope to have you again for the third edition of this Specialized Master.
With pleasure.
Thank you very much.
Thank you.